I have started the recording and we're all set to go.
So it is 7:01 on November 4th. We'll call the Zoning Board of Appeals meeting to order. And we will begin with the Pledge of Allegiance.
I can share my screen for that. Oops. Share my screen if I hit the right button. All right. Should see a flag.
I pledge
Allegiance to the flag
of
of the United States of
America,
and to the
to the
republic
republic
for which it stands,
stands
one
one
nation,
nation,
under
under God,
indivisible,
indivisible,
with
with
liberty
and justice for all.
Meant to roll call. Judy, can you run roll call for us? Because Taylor is absent.
Oh, okay. I'll have to get, okay, let me find the names here. Ryan Buckley. Andy
Here.
Tyson,
Here, I'm in my home in Union Township, Michigan.
Liz
Here in Union Township.
Presnell is absent, I understand. Taylor Sheehan Stahl. Must be absent. Judy Lannon here, I'm in Union Township, Michigan. Brandon LaBelle
Here, Union Township, Michigan.
and Jim Engler. Who must be absent.
Jim was here. He came to the Township Hall and he may be calling in at a little bit later time.
Okay.
Everyone had a chance to review the minutes from our last meeting, which as it were is March 4th. Seems like quite a while ago. Is there any questions or concerns about those minutes? If not, I would entertain a motion to approve the minutes as presented.
I'll make a motion to approve the minutes as presented.
Motion to approve by Judy. Is there a second?
Second.
Second from Brandon. Any discussion? Seeing none, all those in favor, say aye.
Aye.
Aye. Motion carries. Before I skip on to number 5, I guess I'm as a point of order, we're going to officially have called Brandon up as a voting member in tonight's meeting since we have a couple absences. So if you could record that for us in the minutes, Jennifer, we'll have to have Brandon listed as a voting member tonight. Moving on to item 5, correspondence and board reports. In our packet, you see we've got boards and commission expiration dates. Rodney, do you have anything you'd like to add to that?
And not at this time, no.
Okay. Moving on to item 6, which is the approval of the agenda. I have one point that I would like to add, which is Peter sent out the annual Zoning Board of Appeals report to the Planning Commission. So I would like to add that in to our agenda tonight. Are there any other changes to the agenda? Seeing none, we will go ahead and add Peter's the report that Peter provided for us to tonight's agenda. But I would take a motion to approve the agenda with the inclusion of that report.
So moved.
Support?
I support.
Ryan, Judy, all those in favor?
Aye.
Aye. Okay. Let's go ahead and jump right into that report. If you have a copy of that, you want to look at that, or Peter, do you want to speak to that report for us? Give us a little overview on that.
Yeah, so basically what this, for those that have been around long enough, when we were working on our rules and procedure, the Planning Commission by law, they have bylaws. ZBA by law does not have to have bylaws, but they can have what the law described as rules and procedure that they want to adopt. And so we did that. When we created them, it was very similar to the Planning Commission's bylaws, not completely the same, but we used them as a skeletal structure to kind of go off of. And in it, it states that, that before December 1st every year, we will send a report to the Planning Commission, basically informing them of activities that we've done on the year, and also any recommendations that we would have about possibly making changes or items to review in the zoning ordinance. So tonight, of course, we'll be looking at the new zoning ordinance, and we haven't met very much this year, so we probably don't have any new recommendations this year to give them, but it's something that we can look at maybe in 2021 and so on.
Questions about the report? Seeing none, let's move on to open our public comment. It is 7:07 and public comment is restricted to 3 minutes regarding issues not on this agenda. Open public comment. See if we have any takers here tonight.
We do not have any attendees at this time. It would just so the only people on the meeting right now are the panelists that you see.
So we will go ahead and close. That's convenient. All right, 7:08 on my computer. Open for a minute there. We'll close public comment. Moving to item 8, which is new business. Rodney, do you want to run us down through this training work session regarding the new zoning ordinance?
I can, yes. So everybody, does everybody have a copy of the new ordinance, first of all? Okay. I hope you've had a chance to take a peek through it. It's excellent bedtime reading. I highly recommend it for that. So that the new ordinance went into effect September 21st. So we've been operating under it for a little while now. People are starting to get used to it. We've had some time to work with it. Of course, we had some plenty of time during the adoption process to kind of become familiar with it as well. My thought is, if you're in agreement, we'll focus first on the variance and appeal section, which is your bread and butter, and talk about some of the things that are in there. Things may be different, and answer questions about some of those elements, and then we can kind of broaden it out from there. If you have questions on other elements of the ordinance, or like I said, anything else that comes to mind, I'm happy to look at those too. My thought in terms of the format, I don't have slides or anything like that like we did for the earlier training. I can share the screen so you can see the pages from the meeting packet. Of course, you have those as well. But my thought would be is this is informal. As questions come to mind, just you can literally raise your hand if you want. You can raise your hand electronically if you choose, and we should be able to catch those. But you can also simply speak up. With our small group, I think that really is the easiest way to move forward. So in the packet, I guess I'll share the screen to start that part just for a moment here. So in the packet, you have this page up at the top is the section 14.4. This is what we've done here is just taken some excerpts essentially from section 14.4. The packet doesn't have everything, but it has kind of the key elements to look at, and the first element to really take a peek at is this general authority statement, and you'll see several times in this section statements of things you can't do. There certainly is much in here of authority of things you can do as a Board of Appeals, but this first statement that you don't have authority to change the zoning district classifications of property, and you don't have authority to change the text of the ordinance. And you also don't have authority to grant grant variances or overturn decisions involving special uses or planned unit developments. You may be familiar with special use permits. This is where, like, such one item might be a restaurant with a drive-through, might be a special use in a certain zoning district where it needs a public hearing and the neighbors all get notified before it can be approved. So you don't have authority to overturn decisions related to those. Planned unit development you may be less familiar with. That's an optional form of development, basically that combines of rezoning and a site plan together, and it can often involve a mix of land uses. So it might be a residential and commercial project together on one property. It tends to be larger development sites that use this PUD process that's available in state law. So there again, that's a process requires, both those processes require board of trustees approval, and essentially you don't have authority to overturn those items. As I said, we'll be talking more about things you can do. The first one I'd like to talk about is this administrative review process. This is it's basically an opportunity that an applicant has to call into question a decision that Peter makes or I make as a zoning official, whatever that may be, whether denying a zoning permit or issuing some kind of an order for enforcement, anything like that may come up. Some kind of determination that is made administratively under the ordinance. This is the process that an applicant would follow. And of course, our applicant in January, Mr. Merger, did include this as one of the items he tried to do. He ultimately chose not to pursue this one. The change that basically in the new ordinance is on the second page here. Up here at the top. I don't have my mouse. But on the top of the next page, this item C, what you see here, the 4 criteria there, A, B, C, and D, are straight out of case law. So if let's say Peter makes a determination on an issue, whatever that might be, a fence is too tall or whatever it might be, he says no, the ordinance says X and you have Y. Whatever that action was that he made, somebody that doesn't like it, they appeal to you and say, we don't like what he did. Here's all the reasons why we think he was wrong. Essentially, you are under an obligation to review that circumstance. You would be given all the information that Peter had when he made his decision and all the documentation of that decision. And then you would have to find that it essentially meets one of these 4 criteria. The first one, the abuse of discretion. Essentially, he went too far. He just went too far. He pushed too far in making his decision. He stretched the ordinance too far. The second one, that's being arbitrary or capricious. This is the one essentially where he's behaving badly. He is discriminating in some way. He didn't like the color of the person's hair, and therefore he told them no when it really should have been yes. There are number of ways you can be, many ways you can be arbitrary and capricious, but essentially it's an act that's discriminatory in some way towards that individual. The item C there was based on an erroneous finding of a material fact. He simply is wrong. And this is where when you look at the facts, you look at his decision, you simply find that he absolutely made a mistake. He was simply wrong in what he did. And then D is similar in that it's based on an erroneous interpretation. So there again, you look at the ordinance, you look at the facts of the case, and if you find that any one of these 4 criteria apply to his decision, then it's essentially the next step is you as a body become the zoning administrator. you get a chance to redo the decision, whatever it was, redo the determination, that basically sitting in Peter's chair, and together you make you basically act as the zoning administrator and make your own decision in the case, going forward. So this is one that doesn't come up very often. Quite frankly, I'm surprised it doesn't come up more often. It's actually, in some ways, rather than a variance, this can be a better process for an applicant if they truly feel that some decision that was made was simply an error. This is the appropriate process to follow. These criteria are new to the ordinance, but as I said, they're straight out of Michigan case law that has established the criteria for looking at administrative actions, or appealing administrative actions.
Rodney, is it okay for questions right now?
Absolutely.
Okay. I'm curious what your thoughts are on Part D of Section C, in terms of that a decision was made based upon an erroneous interpretation of the zoning ordinance.
Mhm.
What is case law? How is that really, when we say erroneous interpretation, how is that really classified? Because, for instance, I felt like, I think maybe one or two decisions that we did have this year came down to a question of how we were reading the ordinance versus the intent of the ordinance. And I think there was a fair amount of discussion as to, well, we think this is the intent of the ordinance, but it reads this way. And that was kind of at the crux of the issue. So, I mean, does this provide any clarification for us on that particular point? This type of guidance, does it provide any clarification, or is it still basically up to us to say, well, we're interpreting that this is what it meant, or is it just a literal reading of the ordinance?
Now, the first step is where the ordinance wording is plain. You follow the plain wording. That's certainly direction also straight out of case law, is that judges don't want to vary where you can find that the meaning is plain in the document. Now, the sections that have plain meaning are highly unlikely to end up in your hands. You're going to get the ones that are not plain for whatever reason. And ultimately, it is always going to be a judgment call. The Board of Appeals is a judicial body, and you are called upon to make judgments. The case in January is an excellent one for that. You were asked to make some very difficult judgments, and you made them. No matter how much we work to make the ordinance clear, and there was a great deal of effort put into the new ordinance to try to make it clear, to try to eliminate areas where things were vague or contradictory. But no matter what, a zoning ordinance is going to have issues where there's going to be disputes that come up, and that's really why the Board of Appeals exists, is to look at those. So ultimately, you are going to have to make a judgment call on any cases before you. Certainly in the case of an administrative appeal, it is important to respect the judgment of the staff member, of the zoning administrator, to the maximum extent possible. That's, I think, if you kind of look at those criteria there, you can kind of see that they drop down. If the first ones are very obvious, did they abuse their discretion? Did they really stretch the ordinance, or do something they absolutely shouldn't have done beyond their authority? The second one, were they arbitrary or capricious? Were they discriminatory in their behavior? Those are sort of two obvious ones. If you get past those two and you find that they acted appropriately, they didn't discriminate, then you really are kind of coming down to a fine line, a fine decision. And it's certainly not the job of the Board of Appeals to substitute its judgment for the zoning administrator. But it is your job to find if there's an error, in some way. So certainly if you find simply a difference of opinion, then it would be appropriate to err on the side of upholding what the zoning administrator did. But if you truly find there was an error, whether error interpretation or error in fact in some way, then that's where acting to reconsider the decision is appropriate.
So, and if you can bear with me, just if I can kind of put the question just maybe a little bit more simply or from a different perspective, I got the sense, and maybe this was the case or not, but I kind of got the sense that with that example that we were talking about in January, we were kind of focused on, we focused a lot on kind of the literal reading of it, of the language, and maybe not as much as of the intent as you're kind of deliberating, because I get what you're saying. I mean, by the time we've gotten to that point, it's, we are making a judgment call. But I guess what I'm trying to ask is, for the sake of the board here, it sounds like we're permitted to consider intent as well as the literal reading of the ordinance. We can consider it from both perspectives.
Right, and maybe it's a good point a good time at this point to actually look at the next item on the list, right down at the bottom half of that same page, because that, of course, that is exactly what that says. When you look at the next power that you have, which is to interpret the ordinance, the language of that section. It says, as it says there, right at the first paragraph, the ZBA shall make such decisions, interpretations, so that the spirit and intent of the ordinance shall be observed. It is important to look at why the ordinance provision exists. And you'll find in the new ordinance, a lot of places, you'll find purpose statements and intent statements that try to give some meaning as to why this particular provision is in there. Certainly for things like signs, you'll see that. Landscaping and screening often has it. Site plan review and some other, a number of places. And of course, at the beginning of the document, there's a long purpose statement that kind of lays out the reason why the ordinance itself has been adopted. So yes, Ryan, it is important in your interpretation to look at both the wording of the provision itself, but don't get caught in don't get caught in the weeds too far. You want to be looking at the bigger picture of the why, the intent as well. Any other questions about the administrative appeal or interpretations for that matter? All right. I think the other comment I'll make about interpretations is it's noted here. Certainly, you have the ability in the bottom paragraph there, to confer with staff, because a consultant wrote the zoning ordinance. They added the consultant there. I would add the township attorney. You always have the opportunity to consult and get advice before you render any decision that's before you. And I think, as we talked about in March, if you do not have to be in a hurry on any decision. So if you're looking at something and feel that you need to have, for example, counsel from the township attorney before you decide, you have the ability to do that. Simply to say, we need to counsel with the attorney. Here are the questions we need to ask, or we need answers to, and you can postpone action and make the request as part of that to have those questions answered, or to have the attorney present at a future meeting. An applicant may be in a hurry, but that doesn't mean your decisions ever need to be. And so I certainly would encourage that. And like I said, that's one of the reasons why this last paragraph was put in there by the consultant, was just remind you that you do have the ability anytime to seek advice on any questions that you have before you. Well, with that in mind, the next item on our list actually is variances, our big one. Um, and you'll note here on in this section that the criteria for variance has been updated. The language, this is basically a new section. Um, the basic goal of any variance review is still the same, though, and that's in this first paragraph that as it says, by varying or modifying any of the rules or provisions of the ordinance, the zoning ordinance, you want to ensure that the spirit of this ordinance is observed. That gets back to Ryan, your comment about the intent and purpose. Public safety secured and substantial justice done. We'll talk about a little bit more about substantial justice in a moment. But we do have in this first paragraph one more thing you can't do, and that's that you don't have authority to grant use variances. For whatever reason, the State Zoning Act is specific on this point. It really comes down to history. Michigan used to have 3 different zoning acts, one that applied to cities and villages, one that applied to counties, and one that applied to townships. In some cases, the township one was the last one to be adopted. It was adopted in the 1950s, late 50s. And some townships actually adopted zoning ordinances before that using the city and village ordinance. The city and village ordinance allowed use variances. And still, and cities and villages still have that authority. The township zoning ordinance did not, or zoning act did not allow use variances, and so that's why it carried over into this new, I still consider it new, 2006 State Zoning Act. That odd discrepancy between cities, villages, and townships still carried over. Counties also can't provide use variances. So the way the state law works actually is there's about 24 townships in the entire state that have use variance authority. And those were ones that had it under the old laws in one way or the other. So they, in the new law, they were given kind of a grandfathering in and allowed to continue to do it. But Union Township is not one of those communities. So we don't have that option. I guess I can kind of go through these criteria, but I know this is certainly, I said this is sort of the bread and butter of a Board of Appeals. As you've looked at these variance criteria, does anybody have any questions or comments about what you see here?
I want to point out to everybody, some of you have served on the ZBA or other bodies of the township, so you understand the importance of it. But this is one of the things that I think really drives how we make these determinations when we have an application in front of us. So I think it's important that we understand really the ins and outs of how we would be able to grant a variance or what criteria we have to follow, because for every decision I've ever been a part of, we literally took these bullet point items and played them out as a what if. How do we demonstrate, here or there, approval or denial? And that was something that Peter had always helped us with. So I just think it's really important that we focus on this specifically, because almost every decision we have to make, other than perhaps a text interpretation, is the variance, and it's going to be all based on how we play out these criteria.
So with that in mind, I'll just share the screen in another minute here for just to show those. So we start off with the term practical difficulties, and essentially these criteria, as Andy mentioned, the items 1 through 4, Roman numeral 1 through 4, under practical difficulties, they together kind of define what a practical difficulty is. A practical difficulty is not it's not saying that it's impossible to do something. Basically, the idea is let's say let's say we're talking about, let's say talking about building a fence. Somebody wants to build a fence. Um, the ordinance says that the fence can only be so high or in such a location. The idea is that behind practical difficulty is um, that the ordinance does not unreasonably prevent. It's not that just that it doesn't prevent the owner from doing something. Zoning ordinances often prohibit things from happening in certain ways. The question is it unreasonable in how it prevents? Is it going too far? Getting back to that comment earlier about administrative appeals, does the ordinance go too far as applied to this particular case, in that it would unreasonably prevent an owner from using their property in an otherwise permitted way? That, of course, that's that criteria, item 1 there. The terms all the way through this are going to be judgment calls. What is unreasonable? I think is something, Andy, as you said, that would have to be played out. Is the regulation reasonable or not as applied to this property? Because of course, with a variance, we're not looking at the whole township. We're looking at this particular case that's in front of you. And so the first question you're going to need to look at is does it unreasonably prevent the owner from doing whatever it is, putting up a sign, building an accessory structure, installing a fence, building a house the way they want, whatever that item is that they've brought before you. Looking at the reasonableness of the regulation as applied to this particular property is that first step. This language is a little bit different from the old ordinance. The old ordinance language was that asked does a regulation deprive the applicant of rights commonly enjoyed by others in the same zoning district? This language was used to try to focus the question a little better on what actually is at issue with the variance. So rather than looking at depriving of a right, we're looking at really, is it unreasonably preventing a use or unreasonably preventing a development? Number 2 there, substantial justice also is new. The old ordinance referenced the question was that would the variance, by granting variance, would you be conferring a special privilege on the applicant that's not available to others in similar circumstances? Here again, the change was made. This is more consistent with state law, first of all, and also with case law, this term substantial justice. But it was also changed to refocus the question on both the applicant as well as other property owners, neighbors, other people in the area. Because your job is not just to consider the circumstances and the needs of the applicant. Certainly that's an important part of it. But your job is also to look at those that are around. If you remember up at the top, one of the things was the spirit of the ordinance is observed and public safety secured. This is part of that element of considering I guess what I would refer to as the public interest. I think in March during our training session we talked a good bit about this idea of the public interest, and that you have a role to protect the interest of the general public, the interest of the neighbors, as well as looking at the interest of the applicant that's before you. Substantial justice is as I said, it's a legal term. It essentially is really speaking to fairness, and you can probably look at it in that way. Is the variance fair to both the applicant and to others that may be affected or in the area? So it's definitely a balance. You're looking at trying to balance interests here, and just as any judge would do, providing justice to all to the best of your ability. Number 3 in this list is a very important one. You have the power not only to grant a variance or to deny a variance, but you have the power to grant a lesser variance. And so an important question that should be considered in any case before you for a variance is, would a lesser variance provide substantial relief? Just because somebody asks for something doesn't mean that it has to be granted. It's not a yin yang or yes, no. You do have the ability to look at a lesser, lesser variance. In the case of a sign, for example, if somebody's asking for a 20-foot tall, 200 square foot sign, and you look at the circumstances and you look at the case before you, and you say, you know what, there's reason, it's reasonable to look at a variance here, topography or location of the buildings or whatever, that a sign that actually met the requirements simply would not do anything for the applicant, wouldn't be visible, for example, just because of a quirk in topography, let's say. So we're not, but we feel like 20 feet tall and 200 square feet is simply too large, not necessary. And so you look at the circumstances, and maybe you say, well, you know what, a 14-foot sign is reasonable. That would get it above whatever, and would allow allow people to see it. So you have the ability in any case before you to grant lesser relief if you find that that's consistent with the standard of giving substantial relief to the applicant and be consistent with justice to other property owners. You see that's another new element to this, is again looking at justice not only to the applicant but also to neighbors. And then the fourth standard is
I got a quick question, Rodney.
absolutely.
In terms of the lesser variance, is that something that you see us discussing as part of our general discussion when we've heard from the applicant and we're discussing the case, that we would perhaps, I say, I think that it doesn't need to be a 20-foot sign, but I feel like 12 or 16 feet might get it. And I'm asking what everyone else's opinion would be. And collectively, our group feels like 12-foot should be adequate to accommodate that difference. Are we posing that as we're making that suggestion to the applicant that we would grant up to that, and they have to decide to take it or leave it? How would that work?
Well, you certainly should bring it up during the deliberation. I think your practice of going through these criteria one by one, of course, will get you to that place where that discussion would happen, and I strongly would recommend it. So anybody that would feels like I feel like some relief is appropriate. Here's what I'm thinking, and you might say, well, 12 feet I think is reasonable. And then you have that discussion back and forth. That is completely appropriate. You don't have to offer it to the applicant. The applicant, this particular element, when you're deliberating on the case, you certainly can ask a question of the applicant, but the applicant is not part of the deliberation unless you invite them in, essentially. You can basically what you're doing is simply deciding whether a variance is warranted, and if you decide that a variance is warranted, what that variance should be, and then your job is to basically take action to grant that variance. If you have come to that conclusion and found it's the right one, and whatever reasons you have that's the appropriate choice, then I would recommend that you simply go ahead and make the choice. Ultimately, the applicant have to decide whether they're going to use that variance that's granted. But they don't have to. They don't have a role necessarily to say, "Oh no, I won't accept that," but I would accept 14 feet. No, there's no negotiation on that in that sense, unless you choose to bring them into it.
As a general rule, I don't really want. I mean, I don't think we want to get into a back and forth with the applicants. We want to hear their case, and then I think we want to deliberate. If for some reason our deliberation takes us to another question that hasn't been addressed, that's different. But I guess what I'm saying is, if we all felt like the applicant requested a variance that was excessive, are we obligated to say we can't get behind 20 feet, but we can get behind 12, and then let them make the determination if they want to amend their variance? Because I don't think that I'm personally, and everybody else can jump in here. I think that it's I don't feel like it's our job to say what their application should have been, because if you go down to your next point, item B, the responsibility of the applicant to provide evidence. I feel like a lot of times we may be able to make their case better than they could because we know the information, the criteria, that mostly because we're dealing with it more often than they are. So I don't want us to be in a position where we're feeling like we need to be the checks and balance of the applicant. So I want to make sure we've got a good understanding as a group. If we feel like a lesser variance would be adequate, are we just making that suggestion and then letting the applicant choose to take action on that? What is your thought there?
And no, I think that if you feel a lesser variance is warranted, go ahead and take action on it. There's no need for them to amend their application. You have the power to simply grant the lesser variance. You also have the power if an applicant comes in and you find, as you mentioned, the next item down, item B at the top of the next page, responsibility of the applicant to provide evidence. If you find the applicant simply did not make their case, you don't have any obligation to make it for them. If you find that based on the information they provided, that there is no case, period. Even if maybe you could make one, you have no obligation to make it for them. You can simply take action to deny the variance for the reasons you state. Here are the reasons why we believe you didn't make your case, simply deny the variance and move on. The applicant, would have to move forward from there as to how they choose to. But it is not your job to make their case.
I think that Rodney, I think that's a good point. I'm glad you brought that up, because whereas on the planning commission, there would be a sense of helping somebody kind of wade through that process of adhering to the ordinance and making sure that they're giving us an application that is the best application possible so that we can approve what they're asking and that it conforms to the ordinance. But once it comes to something that is essentially a judicial review, I would agree. It's if they're asking us to essentially make changes to our general ordinance, then they should be coming armed with their information in the case they're making. So I definitely agree with that. I think that one of the questions that what Andy was saying was kind of touched on a question that I had about number one as well. I think a little bit at least is, when we talk about strict compliance with restrictions governing an area setback frontage that would unreasonably prevent the owner from using the property for a permitted purpose. I think that, when we talk about granting a lesser variance, to me, in my mind, and you can correct me if I'm wrong on this, but in my mind, we should be trying to tailor a variance so that, for the most part, that it only really applies to this particular site, that we're not creating a variance that then is providing a blueprint for virtually anybody else who comes in and wants the same privilege or the same benefit to come in and ask for the same thing. So, if it's a case of having a 20-foot sign versus a 12 or 14-foot sign, because of a natural contour of the land that others don't have, then, if we say, well, we think this is sufficient for your needs, then that at the same time is trying to, as narrowly as possible, tailor a variance to the specific and unique needs of that applicant, and not something that is necessarily going to be meaningful or impactful to applicant or others that are using their own sites for a similar purpose. Does that make sense?
You've hit it right on the head. Yes, absolutely. You really are looking at this particular case, and yes, the decision should be narrowly tailored. If you find something in the ordinance that you feel is a general issue, if something comes up that truly is a general problem, that's really something where just as you are directed to do as part of the annual report, you absolutely can make a recommendation to the Board of Trustees, to the Planning Commission, to say this really ought to be looked at. This is a problem. Maybe it's a case that's come up over and over. where you have to deal with it over and over. But even if you find something simply on one case where this is really something that should be examined and perhaps amended, you have absolutely the right to make recommendations to, as I said, to the Planning Commission, to the Board of Trustees, to staff, to say, go look at this again. But in terms of the decision you make on an appeal or on a variance, it definitely is narrowly tailored. That's the goal. Other questions? What are your thoughts about the changes in terms of the language from the old ordinance to the new? Any concerns about the adjusted language? All right. The next item on our list was conditions. This is at the end of the section. You have the ability in any matter that you have before you. This primarily comes up with variances, but it can come up with other things too. To place conditions or limitations on any decision you make. So in the case in January where you granted variances for the signs, you also placed conditions, two conditions on the variances that you granted. One of them was directing Peter to double check, to audit the numbers again. And that's fine. That was a reasonable condition related to that particular case. Let's say somebody's wanting to build a building, a pole barn that's larger than the ordinance allows, and you find, for whatever reason, that the variance is warranted to grant a pole barn that is larger in area than the ordinance would allow, but you don't want them to you want to keep the height low for some reason, whatever that may be. So you may grant the variance to say, yes, you can build the pole barn X number of square feet, but as a condition, we're limiting your height to a maximum of X feet, so that that the neighbor's lot is not shadowed, for example. So you're tying it back to some impact on the neighbors, protection in some way of a neighboring property from effects that would otherwise happen from associated with that variance. So essentially, you see here that some direction related to conditions. The key one is, I think, really is B there, that your condition needs to be related to the valid exercise of the police power, which is the zoning ordinance. So the zoning ordinance is a police powers ordinance. We have enforcement power associated with it. So you need to keep within the scope of authority of the zoning ordinance and your authority to as a Board of Appeals. And it also, as item C there, that whatever condition you place needs to be necessary to meet the intent of the ordinance or the standards involved in some way. So again, not an arbitrary decision, not an arbitrary condition. Going back to the pole barn, you grant a larger building, but they can only paint it blue. That kind of a condition and paint color would truly be arbitrary and not consistent with the valid exercise of your powers. So your benefit of conditions, of course, is you can put some fences around your decision. It's part of limiting the scope of that decision, especially in the case of a variance. But you always want to be careful to stay within your own authority and to relate those conditions back to the ordinance itself in some way, and the implementation of that ordinance.
Is a useful life or approval duration? Is that a valid condition to say we're willing to approve this, but only if it's constructed within a certain number of days or something?
Yeah, well, the ordinance itself has language about that. so, basically they do need to act on the variance at some point. What I will say about that though, is that a variance does run with the land. The idea is that it's not a temporary thing. If you believe the conditions exist for a variance today, those conditions should still exist, a year from now or 2 years from now. I had a case, for example, one time. We had worked in a community that had an ordinance that, like ours, in fact, that says that a new single-family home has to have a minimum width. I think it was 24 feet, and which is actually what ours does too. And that's what that is intended to do, is to keep people from putting single-wide mobile homes on individual lots. That's really what that ordinance is for. Is to eliminate single-wide mobile homes as a valid type of single-family dwelling on an individual lot. Had somebody that came in, they wanted to put a single-wide mobile home up on a vacant lot, and it was because they had a sick relative that they wanted to bring in. I mean, very, very powerful emotional case here. They were taking care of somebody that was hard for them. They wanted to move them to this house, but it just happened to have, they had a single-wide mobile home. It was not expected that this person was going to live more than a year or two, and they even offered, to take it away when it was done as a condition of the variance. The problem was that the Board of Appeals has no authority to base a variance on the person. Your criteria is really looking at the property, the physical characteristics, the zoning characteristics, and the land use characteristics, but not the person. And so it doesn't matter if a sick person is going to move into that home or a healthy family. The variance, the criteria have to be met no matter who the person is that's going to live there. And so this particular case, the Board of Appeals in that community, they made the right decision. It was a very hard one to deny the variance. The person ultimately found another solution. And actually, I think the supervisor of that community helped them find a suitable home that could go there. Anyway, the goal always is that you're looking at conditions that are kind of long-term, not something that's transitory. So I would not recommend generally a condition that limits the period of time. Other thoughts? Well, that's all I have with this particular section of the ordinance. Do you have other questions about the ordinance itself, or any other questions about Board of Appeals or the township zoning?
I don't have any additional questions, but I do appreciate going over this, Rodney. I think it's a good addition to the ordinance, and provided some clarity to me, at least tonight, on what we did discuss.
Good. Well, I definitely appreciate your time. It has been a very quiet year, as Peter noted, for the Board of Appeals, and as much as I enjoy seeing you, that's actually a good thing. I have one community I worked in as a consultant that the Board of Appeals didn't meet for 9 years, and that was wonderful. Then they met 4 times in 1 year. Just happened, that's how it worked out. Yeah, I think we will continue to meet periodically, if for nothing else, to kind of have little training sessions like this. I certainly expect at some point you'll have business. It's just the nature of the beast. But in the meantime, if you have anything that comes up, any questions or concerns as you are looking at the ordinance, you're always welcome to call Peter or call myself, or send us an email, and we're happy to answer them for you. With that ends what I have for you this evening related to the training.
9, other business. I'm not aware of any other business on the agenda. Number 10, extended public comment, restricted to 5 minutes regarding any issue. I'm going to officially open it at 7:56. And unless you tell me otherwise, I don't think we've got any new participants. So we're going to go ahead and close it at 7:56, leaving us with final board comment. If anybody has any final comments tonight, any takers on that? Looks like no. And with that, we are adjourned. Thanks everybody for dialing in.
Thank you very much.
Thanks.
You.
Have a good night.
Hi.